Hi everyone, thank you very much for coming to this presentation. Today I'm going to be talking about shelter and rescue law and liability, which I know is something that comes up a whole lot for people both who are volunteering in shelters, rescues who are trying to get animals out of shelters, and also shelters themselves. And I've had many people already come up and ask me questions that are covered by this presentation, which I think is a good sign of what is covered by it. To the extent you have something, like I said, that is not covered, please just go ahead and feel free to ask me afterwards. The things that I'm going to cover are the liability basics, so you kind of understand what a lawsuit is, how it works, how it is that someone can sue you, or what it is they can recover for. Some animal law case studies, which I think are really fascinating. This is the way that we learn in law school. So if there are any lawyers in here that will be very familiar to you, for the non-lawyers it might be interesting to learn how law school works and how people learn through case studies. And a case study means that certain facts were presented to a court, and here's how they decided based on those facts and the law that is applicable to those facts. And then some lessons and strategies for shelters and rescue groups moving forward. I do want to point out, a couple things that are not covered that are related to animal law, because there's simply not enough time to cover everything in an hour. Search and seizure law, so these would apply to a municipality that goes and busts a hoarder or something like that. Dangerous dog contests, which come up a whole lot, far more than I wish they would in Texas, where a municipality claims that a dog is dangerous and tries to seize it from someone. Wills and estates, which actually is a big issue for rescue groups and shelters, because you'd like to get people to donate their estates to you, will not be covered. Abuse and criminal prosecutions is not covered, and Section 1983 is not covered. These are things that are animal law topics that mean a lot, but there's just not time for in an hour. Section 1983 is a federal constitutional right to not be retaliated against for exercising your First Amendment rights. And there are now a couple of cases, 2 or 3 now across the country, where rescue groups have been told they're not allowed to rescue animals because they said something about some condition that they saw at the shelter. And the courts have so far uniformly held that you cannot be retaliated against for exercising your constitutional rights. That's briefly what that means, but it's not going to be covered simply because there's not enough time. Now, this is the most important thing that I need to say and need you to hear, just in case. I am not establishing an attorney-client relationship with you by having this conversation. This is information that I want to give to you so that you can bring back to your lawyer or whoever it is that you work with to make the decisions with regard to liability. The law is different in every state, and it's also different within jurisdictions within states. So this is information, topics that you need to consider, things that you need to think about, and then go to your board, your lawyer, whoever it is that you're going to work with to make these decisions. I'm not giving you advice. I'm giving you information that you can use to make your own decisions. Always, of course, consult a local attorney in your jurisdiction before making decisions with regard to liability. Now, let's get started. So the basics of suit versus liability. How many times have people heard the phrase, "Oh, I don't want to do that, we could get sued for that"? People have heard that before? Yeah. Or "We can't do that because we could get sued for that." Well, guess what? You could get sued for anything. People can file a lawsuit for any reason whatsoever. It doesn't mean you'll be held liable, but they can sue you for anything. So one of the things I like to talk about in this conversation is we're not talking about suit for the most part. There's one exception. We're talking about liability. People can sue you for anything. That should not be a reason you do or do not do something. If people can hold you liable for something, that's very different. That means that upon suit, they could actually recover from you for something. All right, here are the basics of the 3 types of causes of action that I saw most when I did a fairly comprehensive review of animal law topics on cases in the subject areas that I talked about. And there are 3 types of cases: negligence cases, strict liability, and premises liability cases. Now, all a negligence case is basically saying you did something that a reasonably prudent person wouldn't have done. It's a fairly low standard for liability. Strict liability is liability without fault. It means that you could be held liable for your behavior even if you didn't do something that a reasonably prudent person wouldn't do. Meaning you weren't to blame, you didn't fail to meet some standard. It's just that there might be a statute. Usually it is a statute. Sometimes there's precedent, but usually it's a statute that would hold you liable for something even if you didn't do anything wrong. And then premises liability. This is the third type of liability that I saw more often than I expected to in the case law with respect to animal shelters. And this has to do with the physical premises of your shelter or your rescue, meaning somebody sued you for something that they got injured on based on the conditions of your facility, not necessarily based on any activity you did. So those are the three types of causes of action that I saw come up over and over and over again when I looked at animal law topics, specifically with regard to rescue groups and shelters. And you'll see those again, by the way. You'll see them again when I talk about those cases. You'll see negligence come up, or strict liability, or premises liability. And so this is just an introduction to let you know about those. The basics of a cause of action. So this is what it is when someone is trying to sue you. These are the things they have to prove. One, you had some duty that you owed to them. We talked about negligence earlier. Well, if you don't have a duty to act reasonably to everybody, but you do have a duty to act reasonably to some people. So is there a duty that the law imposes on you? Did you breach that duty? Did that breach of duty cause you to be injured in some way? And if so, what should you have to pay if you have breached a duty that caused an injury? So every time anybody says to you, well, we can't do that for liability reasons, well, where is it in here? Is it a duty that you're saying that we have? Is it a breach of the duty you're saying we're doing? Is it causation? How is it going to cause somebody an injury if we do that thing? What are the damages that they could recover? These are the four types of things that you'll see come up over and over and over. It also means that if you're defending yourself in a cause of action, you're defending yourself by saying the opposite of those things, right? Here's a duty. The plaintiff is going to say there's a duty. Your job is to say we do not owe a duty to you. Plaintiff is going to say that you breached the duty. We're going to say, no, we didn't breach our duty to you. Plaintiff is going to say there's what you did caused us problems, and we're going to say, no, our actions did not cause you a problem. It was somebody else's actions or some different action, or ours had nothing to do with you. They're going to say that it caused some level of damages, and you're going to say, no, in fact, you weren't damaged by that. And then there's an additional thing that the defendants can do, which is called an affirmative defense, meaning even if everything that you said is true, you still can't recover from us because we have some type of affirmative defense to the cause of action. An example to that would be sovereign immunity. So if any of you run municipal shelters in Texas, you're actually protected by sovereign immunity, which is actually a protection from suit, not liability. So they can't even sue you if you're protected by sovereign immunity. Okay, so let's start talking about some examples. This is the one that comes up most. This is the one that people ask most about. Well, we can't adopt that dog out because of liability. Or we can't we can't allow this offsite adoption because of liabilities. So you see a whole lot of adoptions being stopped in some places because of concern over liability. And the cases were actually pretty interesting, and they didn't necessarily reflect what you would think they would reflect. So here's one example. DuckDuckGo versus Cassidy. This is from Connecticut. The facts were that a rescue group adopted out a dog to a family. The dog, under the custody and control of that family, bit a third party who then went back and sued the rescue group. Who's ever been worried about this? We can't adopt that dog out because it might bite somebody else and that person might sue us, right? See that it's a lot. Everybody's worried about it. Well, we talked about the causes of action. So the first cause of action that the plaintiff said was that, well, you're strictly liable because we have a statute. Texas doesn't have one, by the way, I don't believe. They have a statute that said you're automatically liable if you own the animal. Well, the court said there's no strict liability there because the rescue group no longer owned or kept the animal. So you couldn't have strict liability, which said that if you're the owner or keeper of an animal in that state, if you're an owner or keeper of an animal and it bit someone, you're automatically liable. Court says no because the rescue group no longer owns the animal. Then it was negligence. Okay, all right. The plaintiff said if we don't have strict liability, then we have negligence liability against the rescue group. And court says no because you don't have any duty with regards to dogs that you don't own to third parties. So the rescue group was not held liable for the bite after it adopted out the dog. Frank versus Animal Haven. This is a New York case, pretty similar. Nonprofit shelter adopts out dog. Dog bites third party who sues the animal shelter. Same facts. And New York also has a strict liability statute, by the way. The adoption contract contains a release of liability, a final transfer of ownership, but says we reserve the right to take back the dog at any time for any reason. So the plaintiff says, well, if you have the right to take back the dog for any reason, you're the owner. And says, therefore, you are liable under New York's strict liability statute because you're still the owner because in that contract you said you had the right to take back the dog for any reason. Fortunately, the court did not agree. They said on the dog bite strict liability statute, the shelter has no liability because it was not the dog's owner, even though it had that language in the contract. But the court was not convinced that the reservation of right to take back, the court was not convinced that the reservation of right to take back the dog prevented full transfer of ownership. But the point here is that you could be more subject to liability if you have that kind of clause in your contract, because someone could argue, and possibly could successfully argue, that you still own the dog, and therefore you're still liable for its actions. Miles versus Rich. This is a Missouri case. All of these are pretty recent cases. Again, you see the same type of fact pattern. Humane Society of Missouri adopts out a dog. The dog bites a third party who sues the owner. Owner then turns around and sues the Humane Society. They bring the Humane Society into the action on a third-party claim. Here it was held again, no liability against the Humane Society because it did not own, possess, harbor, or control the dog when it bit the plaintiff. So over and over and over again, I saw in the case law, cases where a rescue group or a shelter adopted out a dog. It then bit another person who sued the shelter and said you should never have adopted out that dog. Over and over and again, I saw the courts determined the shelters were not responsible because they did not own or control the dog any longer. Another New York case, Galgano versus town of North Hempstead. Here the facts were that the town shelter, so here's a municipal shelter, adopts out the dog who bites an individual. The individual sues the shelter for adopting out what they say is a dangerous dog. Again, held no liability under the dog bite statute because the plaintiff did not prove that the shelter, in this case, said there was yet another prong of that strict liability statute in New York, said that you had to have a reason to believe that the dog was dangerous in some way. So it wasn't just that you had to own it, but also that it had to be that you had to know or should have known of its dangerous propensity. The court says if you didn't know that that dog was dangerous, if you didn't have reason to believe it was dangerous, you're not going to be held liable for it. So this is a different defense, but essentially to the same claim. Hopefully that makes sense. So you might have multiple different reasons to get out of liability, even if the claim is the same. I assume, because I saw those other New York cases, that they could have also said and won on the grounds that they simply were not the owner or controller or keeper of the dog any longer. So you can actually get out of liability in multiple ways. Mensch versus Inglewood Humane Society. Inglewood Humane Society adopts out a dog who bites the adopter. So here we have a slight variation on the facts. Instead of biting a third party, it bites the party who, in fact, was the adopter of the animal. Then turned around and sued the Humane Society, but again, no liability. Court held no liability because the Humane Society no longer owned the dog. But, the court wrote, the plaintiff might have been able to sue for breach of warranty or for fraud in inducing the plaintiff to purchase the dog by making statements as to its qualities without having sufficient knowledge to warrant the declarations. This is really, really fascinating because I find that people say things like this all the time. And the court held basically here, you might have been liable if plaintiff you had thought of this argument. But since you didn't think of it, defendant wins. But here's the problem, and I'm going to talk about this later, that you could be subjecting yourself to liability by making promises with respect to the temperament of the animal. Good with kids. Good with cats. Have you ever heard yourselves do these things? Have you ever heard somebody else say these things? These are the type of things that this court said could get you into trouble because you're making a warranty or promise with regard to the future behavior of that animal. Now, what you could have said was, person who turned in the dog reported that the dog was good with kids. That's not a warranty. That's not a promise. That's simply a fact. But if you put on, and I see it on almost every animal shelter I go into, they have put little stickers on the kennel cards. Great with kids. Great with cats. You're making a warranty with respect to the future behavior of the animal, and that could subject you to liability. All right, volunteers. There's another area. A lot of shelters I've heard say, we can't allow volunteers in here because they could get bit. I think I got an email this week from somebody saying that their shelter said they couldn't allow volunteers to walk pit bulls because of liability. Again, though, what you saw was very rarely were these shelters being held liable. Brown versus Northwood Animal Shelter, this is in Michigan. Volunteer worker slips and falls at the animal shelter, then sues the animal shelter for the injuries. Of course, this could very well happen a lot, right? Because you're cleaning cages all the time. It's very easy to fall. A dog might pull you over and you might fall. And note that this is a premises liability because they're suing about the condition of the shelter. They're basically saying that it shouldn't have had a wet floor at the shelter. And this court held that there was no liability in the case because the volunteer had signed a written waiver of liability. So simply the act of the volunteer having had to sign a waiver before they could volunteer, saying we're not going to sue for, among other things, premises liability, meant that they could not recover against the shelter under that circumstance. Fire Insurance Exchange versus Cincinnati Insurance. Now this is kind of an interesting case because it got far more complicated than it needed to be, but it's a really fascinating case. Dog owned by a third party was at a Humane Society event at the Humane Society, even though the dog was not owned by the Humane Society. Somebody brought their own dog, basically, to a Humane Society event. Bites a 12-year-old child. Parents sue the dog's owners, whose insurance company settles the case and then turns around and sues the Humane Society. That's just a long way of saying that the Humane Society got sued for the 12-year-old getting bitten. The court held that the Humane Society could be sued as the keeper of the dog, even though it was not the owner of the dog, because it was under the Humane Society's care at the time, even though it didn't belong to them. So most of you in the back of your head are thinking, okay, we probably shouldn't let people bring their dogs to our events because then we could theoretically be liable for the behavior of that dog. But the second interesting fact of this case is the parents had signed a waiver that they wouldn't sue. But the court held that because it was a child, the waiver had no effect. Child cannot waive liability, and the parents could not waive liability for the child. The court, in fact, said that the shelter could have been deemed to have violated child labor laws and therefore wiped the waiver clear. A lot of shelters love having kids at events, love having kids interact with the animals. But you need to know that most lawyers, I'm not an employment lawyer, but the lawyers that I've spoke to who are employment lawyers have told me that they do not recommend that kids work at animal shelter events because of this very reason. You can't waive liability. Now, of course, there are other ways to reduce liability, and we're going to talk about those at the end. So waivers are not the only thing you can do to reduce liability, but you could be subjecting yourself to liability if you do have children at your events and working directly with animals. Offsites. Another thing I was told in Austin, we can't have offsite adoptions because of liability. My question to the shelter director at the time was, I forgot that you went to law school. Which law school did you go to again? And that was met with silence. But most people who say, we can't do something because of liability have no idea what the law is. And that's why, it's really important to understand the basics. Claps versus Animal Haven, another, I think that was the same group, so apparently this group gets sued a lot in New York. Dog available for adoption outside of Petco. How many people have Petco or PetSmart or offsite adoptions at stores, right? So this is the kind of thing that could happen to you. Dog available for adoption outside Petco, bites a Petco customer walking by. Customer then sues the animal shelter, whose offsite adoption it was. Probably sued Petco too, I think, but definitely sued the animal shelter. The court held that there was no liability under that New York dog bite statute that I kept on referring to earlier because the shelter did not know or have a reason to know of a dog's dangerous propensity. So what does this tell you? If you have a dog that you believe might be dangerous for some specific reason, don't bring it to an offsite, right? You have to be smart. I mean, the basic rule of defending yourself, of reducing liability, is don't do stupid stuff. And if you had a reason to believe that a specific animal was dangerous to the public, you shouldn't be bringing it to an event where the public is. pet custody disputes. There were a whole bunch of these in the case law. I was really surprised by this. A whole lot of cases in which people are fighting over who owns an animal. So here's one example. Lemire versus North Country Animal League. This is a Vermont case. Dog impounded, and this is actually, these are the facts of a case that happened in Houston recently too. Dog impounded as a stray, held for the entire hold period at the animal shelter, then was transferred to a nonprofit or rescue group. So how many people do that? Take animals after they've gone through their stray hold, right? The prior owner, who had been looking for their dog all along, finally found it from that shelter, the North Country Animal League, who turned down the previous owner. Again, we go back to the don't do stupid stuff thing, but they turned down the previous owner. And then someone sued the nonprofit. So then they turned around and sued the nonprofit because they found out the dog was adopted to somebody else. But the court said there's no liability for what they viewed as public policy reasons. They said the nonprofit shelter gained complete ownership at the when it was transferred to it because of the expiration of the hold period. Meaning that once that dog or cat's hold period has expired, the ownership, at least in that state, transfers automatically to the animal shelter, who can then transfer ownership to someone else. So by and large, and this was consistent across the case law, by and large what I saw is courts say, look, we can't break down animal control completely. We would completely turn animal control on its head if after the expiration of the hold period, the animals still belong to the previous owner, right? Because then they couldn't be euthanized, they couldn't be adopted out, they couldn't be rescued, they couldn't be anything. And the courts are saying, no, we're not going to allow that to happen. Haynes versus Hampshire County Commission, very similar case. This is West Virginia. Dog impounded as a stray, held for the 5-day hold period there in that community, then adopted out. Same thing, prior owner who had been looking for the dog the whole time, found out, sues the county. Again, the court, however, says no liability for public policy reasons. Liability would render animal shelter laws completely void. So once that hold period is expired, the courts are saying ownership transfers to the shelter, and then that shelter can transfer it to anyone else, whether it be a new adopter or a rescue group. It was interesting to note, again, here's where the courts sometimes throw stuff into cases that it's not actually applicable to the case, but it's a good warning. It serves as a good warning. The court said it could not order the return of the dog because it was no longer in the shelter's custody, because in this case they had already adopted out. So it's possible that you could get someone suing you while you still have the animal that they owned. This court was suggesting at least a little bit that it might have been able to order the animal to be returned to you. However, in my opinion, if the ownership has completely transferred, then it's completely transferred, and they wouldn't be able to order the dog to be returned. So here's the Houston case. Anybody from Houston? I know there's some people from Houston here. This was a huge case. It was in the news. Lyra versus Greater Houston German Shepherd Dog Rescue. Very similar facts. Dog was impounded at Bark, I think. Bark or Harris County. I think it was Bark. I think it was Bark. Held for the hold period, then transferred to a rescue group. Prior owner finds out and sues the rescue group saying, we want our dog back. The trial court held, it was the first court I had ever seen do this, trial court held that in fact the dog did belong to its prior owner even after the expiration of the hold period. And worse, held that the rescue group converted the dog, which is the civil description of the word theft, meaning basically the rescue group stole the dog. And the rescue group was ordered to either return the dog or pay a whole bunch of money in damages. This was a big problem because it essentially put animal control and rescue groups all subject to greater liability. Because if you can't own the dog or cat that comes to you after the expiration of the hold period, what else can you not do? Well, you can't vaccinate it because you don't own it. You can't spay or neuter it because you don't own it. You could be held liable for euthanizing it if you were at a shelter that euthanizes because you didn't own it. These were huge problems that were created by that case. And before this was determined on appeal, what I told people is I think it's absolutely wrong. It has to be wrong. It has to be that once an animal's hold period is expired, that the ownership transfers to the shelter who's holding it, and then to any rescue group or person who adopts it or rescues it afterwards. And fortunately, the Houston Court of Appeals agreed. They reversed the trial court's judgment and rendered judgment in favor of the defendant, the German Shepherd Rescue Group. They held that to have civilly converted something, i.e. stolen something, it requires the plaintiff to have a superior right of possession to the animal. They actually they punted on ownership. They said, we don't have to decide ownership. We're just going to look at the cause of action that you sued on, which was conversion. And the cause of action that you sued on requires you to prove that you have a superior right of possession to the defendant. And they held that you didn't have a superior right of possession because after the hold period, the former owner no longer had superior right of possession. The shelter did, and the shelter could transfer its possession to a rescue group. The plaintiff in this case is appealing, which is why it says petition filed at the end of that. So it's not a final decision at this point, but if I had to bet, I would bet a lot of money that the Texas Supreme Court will not overrule that decision. And the other interesting fact about this case is there were a lot of amicus briefs filed in this case, which is a brief filed by a group who is not a party to the case. It's a really interesting thing that all animal shelters should be thinking about. When there's a case that's going on that dramatically affects you, even though you're not a party, you can file what's called an amicus brief in the case, which basically tells the court, look, the facts of this case will have the decision in this case will have a huge impact on us, and we think you should decide it this way. So the ASPCA, Best Friends, a whole bunch of rescue groups in Houston all filed briefs in support of the shelter, in support of the rescue group, and then all of the purebred organizations in Houston and Texas and the U.S. filed briefs in support of the owner, saying, no, once you own it, you always own it. And the court dropped a footnote saying, we appreciate the amicus briefs, however, we don't decide any of the issues presented in the amicus briefs. We're just deciding that you don't have possession of a superior possession of the animal. So I think this is the right decision. They decided on as narrow a manner as possible, which I think is probably the right thing for the court to have done, and I think it's right. And that matters for anybody who's in the Houston area. That's going to directly affect you. Fager versus Warwick Animal Shelter. Here's another slight change to the facts of the same scenario. A prized, famous show cat was stolen from a woman's home, then surrendered to the animal shelter and adopted out to a new owner. The prior owner found out and then sues the animal shelter. This is the only case where I found that, in fact, the shelter could possibly be held liable. And this court said, well, I'm going to allow the suit to go forward if the plaintiff proves that the shelter knew that it was her cat and knew that she was looking for it and adopted it out to someone else anyway. Again, we go back to the don't do something stupid rule. If you find an animal, you clearly know who the owner is. You know that the owner is looking for it. Return the animal to the owner, especially during the hold period. Don't play games with owners. If somebody owns the animal, it's probably the best, at least this court is saying it's the best scenario to give the animal back. But this was a rare case because it was a case in which the court believed that this cat was so famous that the people at the animal shelter knew who it belonged to. Most of the time, you're never going to have that, especially with cats. I mean, how many people have cats, lots and lots of cats coming to their animal shelter and they know who the owner is? All right, some more miscellaneous topics. This is a foster case. I was really fascinated by this one because I didn't think I was going to find that because it's kind of new in animal welfare that we now are fostering animals. And here's a case about fostering. It's a dog foster and also a foster to adopt situation. Anybody do that where you sign some agreement that says you're going to foster it for now, but you're going to adopt it later? That's what this scenario was. Foster to adopt situation. But the dog foster started doing something dangerous, reading on the internet, and convinced herself that spay-neuter was in fact bad for the animal. Now, I'm not here to debate that. There actually are probably some studies that say that spay-neuter is bad for animals, but we support it anyway because it's good for the whole. It's good for the community as a whole. But she started doing all this research and convinced herself there's no way I'm going to let them spay-neuter this animal. It's bad for the animal. She wanted to show the animal. She felt like she couldn't show it if it were spayed or neutered. There was a written foster agreement that made clear that the rescue group owns the animal. But it did not say anything about having to return the animal upon demand. Didn't say anything about spay-neuter. But, however, the foster agreed that there were additional oral agreements to spay, that she had promised that she would allow the animal to be spayed or neutered. But she wanted to keep it. She said, it's a foster to adopt situation, therefore I own it, and I get to keep it, and I get to do whatever I want. Worse here was the fact that the animal shelter was threatening to cut off the rescue group's rights to pull animals because the animal wasn't spayed or neutered. And that actually happened in Austin several years ago too, where a foster basically stole the animal and disappeared, and then the animal shelter told the rescue group, guys, we're going to cut you off because you can't prove that that animal was spayed or neutered. So that's a big problem. The court ultimately held that the foster ordered the foster to return the dog or have it spayed. You can either have it spayed and keep it, or you can return it back to the rescue group, because that's what the contract said. Contract said that you had to do those things, therefore we're going to do it. Now my note is that the foster contract could have been a lot stronger and should have included spay-neuter requirement and the requirement that it be returned on demand at any time. That's what, if you were trying to achieve greater power and authority over your fosters, you need to do that in your contract, your foster agreement. Here's another miscellaneous one that applies to any groups that are within Austin or the surrounding areas that would be covered by the Austin Court of Appeals, because this is a local case. Dog adopted out from an animal shelter, from the city of Elgin Animal Shelter. At the animal shelter, they were promised this dog's good with kids. They were told this dog is really good with kids. On the afternoon of the adoption, the dog mauled the child, and it turned out, I think it was a police dog or something like that. Owner then turns around and sues the city of Elgin for adopting out a dangerous dog. And this court held that the claim was entirely barred by sovereign immunity. We don't have to look at any more facts. All we know is that it was adopted from a municipal entity. And if it's a municipal entity, it's barred by sovereign immunity, which just, because I didn't explain it earlier, is the idea of the king can do no wrong. That's the old British version of the law. The king can do no wrong, you can't sue the king. And that has been imported into the law in most states in the United States, not everywhere. Louisiana, I think, in their constitution waived sovereign immunity, but in most places, governments are protected by sovereign immunity to the extent that they don't waive it. In Texas, there is a tort waiver of sovereign immunity called the Texas Tort Claims Act, and it waives sovereign immunity, but only for specific things, and this court held that running an animal shelter is not one of the things that sovereign immunity is waived for. So at least with respect to government animal shelters in the Austin Court of Appeals, this is the law, which is that you simply can't even sue the animal shelter for that. And I think that would be persuasive authority in Texas, meaning that a court could decide to follow it in another jurisdiction, but wouldn't have to. And this was really interesting too. Can an animal shelter, a municipal animal shelter, be sued for failing to impound a dangerous dog that they know about? In other words, somebody keeps on complaining, this dog is biting people, this dog is running loose. And can the shelter be sued for failing to act on the information that they have? 2 courts said no in New York and California. 2 courts said yes in Tennessee and Washington. But these were cases, in my opinion, I think the answer is no, because governments have to have authority to make decisions about who they're going to essentially prosecute and who they aren't. In both of these cases, in Tennessee and Washington, there were egregious circumstances. And I think that's why the courts went the other way. And I think this is the lesson of, if anybody's ever heard this said, bad facts make bad law. The facts were so bad in these cases that the court kind of looked the other way, I think, on the law and decided in favor of the plaintiffs. I believe it was the Memphis case, there had been a previous dangerous dog proceeding. It was owned by a police officer. There had been a previous dangerous dog proceeding after the dog had bit many, many people. And the police ran the dangerous dog proceeding, and their police officer's dog it was, and they kind of nudge, wink, wink, said, oh, nothing to see here, no problem here. And the court said, look, everybody knew it was dangerous, and you should have done something about it. But I think that's probably wrong. But again, those facts were so egregious that that's what the court said. And in both of the other cases, New York and California, they said there's no way we can hold municipalities and governmental units liable for exercising their discretion to determine what they are or are not going to do with the limited amount of time that they have. All right, strategies to reduce risk. Again, I'm not giving you advice, I'm giving you information so that you can decide what steps you want to take. So all of the things that I'm going to present to you are options that you can use, that you can choose to implement to reduce risk. There are basically three things. You can change your own conduct to reduce risk. Remember I talked about, for example, you could choose not to have children in situations in which they might get hurt. That would be a way that you could change your conduct to reduce risk. You can reduce your risk of liability by contract, meaning requiring someone to sign a contract in advance of something that they are going to do with you that waives your liability for them getting injured by that activity. Or you can buy insurance, which means that, yeah, I could be held liable for all these things, but I have an insurance contract that's going to pay if I end up getting sued and it has to pay out. Also, often the insurance company will pay for your defense if you have an insurance contract that requires that. So then you don't even have to hire lawyers. The insurance company would be doing that. Conduct. Here's an example. Incorporation. How many are you at rescue groups? Yes. How many of your rescue groups are incorporated? How many of you don't know or are not sure? Okay, you are. Good. So what incorporation does, incorporation is a legal myth. What it does is it creates, it's a fiction, they call it. And it creates a wall around your behavior such that only the corporation can get sued and not the people that are running the corporation. And the whole concept of it was if there's a large corporation that hurts somebody, you can sue the large corporation, but you can't sue the president of the company. You can't be personally liable. Now, there are some exceptions to this, but that is one way to protect yourselves individually from liability, which is to be incorporated. Incidental benefit is you have to be incorporated to apply for a 501c3 in order to get tax-exempt status. Another one, adoptions. What can you do to reduce liability in adoptions? Well, the first thing you can do is observe, document, and disclose so that there's never information that you know about the animal that the adopter doesn't. And the idea of this is the adopter cannot sue you for either, or they can sue you. They're not going to sue you, or you're not going to be held liable for making a decision when they're making the same decision based on the same information. So if you've given them all of the information you know about the animal, for example, that the cat scratched somebody, or for example, that the cat has an injured leg, well, then they're not going to be able to hold you liable later for failing to tell them that the cat had scratched somebody, right? So observe, document, and disclose. Tell your adopters everything you know about the animals, and then let them make the decision as to whether or not it's a good fit for them. In fact, I say give your adopters a copy of everything that you have. Copy your records on the animal and hand it over with your adoption. Now keep it in case you ever do get sued later, but that way you'll be able to show, look, we gave all of this information to them. They're the one that made the decision. They can't sue us for making the same decision that they made based on the same information that they did. And again, not necessarily limited to behavioral, give them the medical information too. If the animal's been treated for something, let them know. Let them know what vaccines it has or hasn't gotten. Just give them the same information that you have so they're making an informed decision about the animal, and they can't go back later and say, you didn't inform us of X, Y, and Z, and we would have never adopted the animal if you had. Warranties and promises. Remember I talked about that case earlier where the court said, you know, we're not going to hold you liable, but plaintiff, had you thought to file a breach of warranty case, I would have held you liable. That's what that one case said. So it is risky to make predictions, warranties, or promises regarding the health or temperament of an animal. It is risky to say this animal is perfectly healthy. It is risky to say this animal is good with kids or good with cats or good with other dogs or good with small dogs or good with old people or whatever it is, because you're making a promise or warranty with respect to the animal. What could you do? What's safer? Sticking to the facts. For example, this animal lived in a household with kids who were around it every day, and the previous owner of the animal reports that the animal was good with kids. You are not making a representation with regard to the future behavior of the animal. You're simply giving them information that you know about the animal that someone has reported to you. then they can make their own decisions. I got to do questions at the end because they're recording, but write it down. So it's not a fact to say an animal is good with kids because you're making a warranty about the future, or a dog is great with other dogs or cats because you're making a warranty about the future. You're subjecting yourself to potential liability by doing that. Here's a hypothetical. I found this in one of the writings on the internet, which I thought was really fascinating. Customer has a 12-year-old child. On the website of the animal shelter, it said, not recommended for home with children under 10 years old. Dog bites the 12-year-old, family sues the shelter for misrepresentation, for breach of that warranty or that representation. Is the shelter's conduct okay? Was that a fact or was it a prediction? What could the shelter have said instead? Now, interestingly here, this is the reverse, but it's still a representation. By saying this animal is not recommended for a home with children under 10, you are saying this animal is recommended for a home for children above 10. And therefore, this person with the 12-year-old, you have made them a warranty that the animal is good with 12-year-olds. Now, I would suggest to you that there's not a single person in an animal shelter who knows at what age, who really knows as an expert at what age a potential adopter is going to be good or bad for that animal. And I think we should get out of the business of making such promises. But what you could have simply said was, this cat has been around volunteers who are young and has behaved fine. That is a fact. That would be fine. But to make this, even this negative warranty of not recommended for children less than 10, you're making a warranty about the animal that the children is okay that the animal is okay for children above 10. So just, in my opinion, if you want to reduce your liability, get out of the business of making predictions about the future behavior of the animal. Also, your premises. So premises liability, I talked about that earlier, is the idea that you could be sued or held liable for something that happened on your premise, a physical condition of your premises. What are some of the things that you can do to reduce your liability with respect to premises? Provide warnings or cure defects. That's what a premise liability suit is going to be. They're going to say that you failed to either fix the problem or warn us of the problem. Meaning, let's say there was a wet spot in the middle of the hallway that somebody slipped on. They're going to say you should have either fixed the wet spot or you should have warned us. If you had done either of those two things, you wouldn't be held liable under the premises liability theory. So what you need to do then to reduce your risk of a premise liability lawsuit is to either provide warnings to the extent you know of risks or fix the risks or cure them. Warn or cure. Those are your two things that you can do, or both, of course. Now, if you are in a business setting, not in a home setting, but in a business setting, you're also going to have the duty of having to have warn or fix things that you should have known about. Not just things that you knew about, but things that you should have known about. So in the business setting, if you run a shelter, for example, where the public can come in and out of, you also need to, on a probably at least a daily basis, maybe even an hourly basis, just make sure, go through that shelter and make sure that you are not having things that could hurt people. This is why, for example, if you're ever at a Walmart or anywhere else that has that somebody's cleaning the floors, they put up those yellow placards that say warning slippery. That's why they're doing that. It's because they have warned you about it. Once they have warned you, they have done all they needed to do under the law. If you have people cleaning while your customers are there, you have to have that same warning out. So you can say that, this area is being cleaned at the moment. We're warning you of slippery conditions. I actually did see a case, I think it's probably wrong, but it was out there, where a dog got out of a kennel at night and escaped from the shelter, ran into the road and was hit by a car. That car hit another car and somebody got seriously injured. And they held the shelter liable because the condition of the shelter was such that a dog could get out of the gate. So you got to be very careful about the condition of your facilities. Also, it's been recommended in some articles that I read to separate your intake area from your other areas, because your intake area, you're taking in animals you don't know anything about. And whereas your public areas where people are adopting animals, then you're going to have the public coming in and out. So one of the articles I read recommended separating those two areas because you don't know enough about those animals on intake to protect people. You can also keep animals separated if you have, for example, a spay-neuter clinic or something like that. Just keep that to the side so that you're not risking more liability for yourself. Eliminate blind corners. For example, one of the articles I read said that people were getting bitten when 2 dogs were coming around the corner at the same time, or one person was coming around the corner with a dog and a person was coming around the corner. Just eliminate those by putting up mirrors or having a system where that's not going to happen. What else can you do? Of course, you can adopt policies and protocols. Again, I'm not an employment lawyer, but here are some things you can do. You can have written policy protocols for employees, volunteers, and board members so that they understand what the rules are when they're at your facility. You want your employees and your volunteers to sign to prove, so that you can have proof that they received these things, sign something that says that they received it. Safety training, of course, for all employees and volunteers. They should know, for example, that if there's a wet spot, if a dog had gone to the bathroom on a concrete area that people are walking by, they should know they need to either clean it up or put up a warning or at least let you know about it, let maintenance know about it. And then employment law training such as sexual harassment. You want to follow any employment law guidelines for that. All right, adoption agreements. This is probably what a lot of people were here to hear about. Here are some things that you could do to reduce risk. Expressly disclaim any oral promises, warranties, and contracts. So the first thing you're going to do is in your contracts, what we talked about earlier, if you wanted to reduce risk, you're not going to say, good with kids, you're not going to make these promises. Great for a household with kids, great for a household with cats. But one of the things you can do in addition to that is in your contract, in your adoption agreement, is say, you agree in advance that you are not adopting this animal based on an oral representation of any person. And we disclaim any oral representation that you've seen. This is the only contract, and these are the only rules that govern our relationship. That way, just in case you have a volunteer or someone out there who did make such an oral representation against your policies, this would give you at least a little bit of protection. But you, of course, also have to make sure that everything you need is in that contract, because if you say that, then nothing else counts. Only the things in the contract. And of course, there's also this possibility that someone could claim later that you essentially lied to convince them to sign the contract. Okay, so it's really best to be as safe as possible and just not provide these warranties about the future behavior of the animal. In your adoption contract, you do want to make sure that the ownership transfers to the adopter so that you are no longer liable for the animal. Make sure ownership 100% transfers to the adopter. And consider an arbitration or mediation requirement. Almost every thing you sign today has an arbitration or mediation requirement in it. Your cell phone contract, your utilities bill, all those things that you sign. Remember those pages that you click through on Apple saying okay, 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 okay when you get a cell phone that you don't read? They all say you can't sue us, you have to go through an arbitration or mediation led by someone of our choosing. And that keeps the case out of courts in most states. Foster agreement, same thing. Remember that case that we talked about where the foster kept the animal and they were trying to figure out what to do. If they had a better foster agreement, a stronger foster agreement, they wouldn't have had that problem. Same thing though, you want to disclose anything that you know about the animal to the foster. If you don't know anything, you can't disclose it. But to the extent you know stuff about that animal, you want to disclose it to the foster. So they're not going to, probably not going to sue you later for failing to disclose something that you did disclose. You can also require them to waive all liability against the rescue or shelter, state in the foster agreement, things like animals are inherently unpredictable and may subject you to risk of illness, disease, or injury. And here's what we know about it, but there are a lot of things we don't know. And state that the foster agrees to be subject to any additional unlisted requirements by the shelter at any time. Meaning if something comes up later and you're like, we got to go get that animal, then they're going to be subject to that in advance. Also make clear that animals belong solely to the rescue group or shelter and not to the foster. That unlike the adoption agreement, that ownership of the animal does not transfer to the foster. That should be in the foster agreement itself. Make clear who has authority to make decisions for the animals. Does the foster, for example, have the ability to go to their own vet? If they do go to their own vet, who has to pay? These are the type of things that you want to think about in your foster agreement. Who has to pay if they do that? Who has to pay for the vet? If an animal that you own is taken to the vet could theoretically say, well, then you guys have to pay for it, unless you have some foster agreement that says no. And if you do that, you're the one that's responsible for the payment. Require that animals be kept on a leash at all times or contained in the house. We've had situations at APA where people have let their foster cats outside and then they disappear. Put in the contract that they have to keep them inside. And also require fosters to report any health or behavioral incidents. Because once they're your fosters, they're within your knowledge as far as the law cares, right? So if something happens at a foster home, and then that dog or cat is adopted out and repeats itself, they could claim that you failed to provide that information to them. Even though you, as an organization, didn't know, your foster did, and they're part of your organization. And I recommend that fosters be kept separated from all other pets in the household, so they can't later claim, well, this animal was sick and got my cat sick too. Waivers and agreements, now the volunteer agreement. Same thing, you just want to have really strong language in your volunteer agreement. You, for example, can require them to waive all liability against the rescue or shelter, to indemnify, I like this too, indemnify the rescue or shelter for injury caused by the volunteer. State that animals are inherently unpredictable and may subject them to risk. State that a volunteer agrees to be subject to any additional unlisted rules that the shelter or rescue comes up with. Require that volunteers report to the rescue or shelter anything about an animal. So if you have a dog walking program, for example, and something bad happens, an incident happens, you want to make sure they report that to you so you can put it in your list that you're going to turn over to potential adopters. And again, I was told, not an employment lawyer, but I was told that the safest practice is adults only. If you have kids, you want to put them in a situation where they're volunteering at a very minimal risk of being harmed by anyone. And then insurance. There are many different types of insurance, and I've talked about some of them here. There's workers' comp insurance, which would cover the shelter or rescue with respect to their employees. There's general insurance, which is a private insurance that would cover you for your operations. You want to make sure that your operations, your volunteers, your premises, make sure all of that is covered in your insurance. Make sure offsite adoptions would be covered, and it's not just your shelter, but also if they bring them somewhere else. Directors and officers liability. If you have a board of directors who's particularly concerned about liability, despite the fact that there's the fiction of a corporate entity, then you can get insurance for them too. It's probably pretty cheap because it's probably fairly rare that an officer or director would ever get held liable for something. Automobile, this is something I read about on another website that was really interesting. You want to make sure that your shelter employees are covered for your shelter's automobile, but also for your employees when they're using their own employees to do your work. So if you have shelter employees or rescue employees who are using their own vehicle to go to an offsite adoption, you can get auto insurance that's going to cover that too. And then events. This event, for example, I'm fairly certain, I didn't run it this year, so I'm not 100% sure, but usually you want to get insurance for an event too. And it tends to be not very expensive because depending on the type of event, it's pretty rare that somebody's going to sue you or hold you liable for something. But if you have a big event where the public is could be interacting with animals in any way, you want to make sure that you're covered for that too. Additional resources, these are two good resources that I found elsewhere. Best Friends has a sheet. If you just Google insurance covering your tail Best Friends, you can find a sheet where they talk more in depth about insurance. And then Animal Farm Foundation wrote a piece, it's a lawyer who wrote this piece called Liability Hysteria, which basically reaches the same conclusions that you could reach from most of the cases that I put up there, which were that in most cases, shelters are not going to be held liable for something. But again, as I said earlier, don't do something stupid. That's the main goal of any legal presentation, is if you stop doing stupid things, and you start doing smart things, and then you implement the things that I talked about. You change your conduct to reduce liability, you get contracts to reduce your liability, and you get insurance to reduce the impact of liability if you actually get held liable. Those are the ways that you can protect yourself. And that is all I have. So, if you've got any questions, I am here to answer them for at least a few more minutes.